In this video, I want to talk about an interesting interplay between revocable living trusts and durable powers of attorney. This is a prime example of how using form documents that you find online or not dealing with a lawyer can get you into trouble, because the companies that offer this stuff online or these free forms obviously aren't taking a holistic approach to what your needs and what your desires are, because they don't know you. You're just clicking buttons or you're just downloading free forms. So here's an interesting example, because I'm dealing with a client now who downloaded some free forms off the internet, and we now have an issue that's going to be more expensive for them to deal with. And the idea is, a power of attorney, a durable power of attorney, may have a provision, and if it's properly initialed, because it's one of the superpowers that has to be initialed in order to be effective, and I'm going to do another video on what these superpowers are. It may have a provision, though, that says your agent, right, the person you elect to be your decision maker, your agent can amend your trust if you want to give them that power. You don't have to give them that power, but you may choose to do so, and there are lots of reasons why that is worthwhile and useful. And I got a very specific example of a client I'm working with now where we need to amend that trust and we can't. And it's not because of the power of attorney. The power of attorney has the proper initials and has the proper language. It says my agent has the ability to amend any trust I have created. However, the problem is, Florida statutes, and this is a Florida problem, might be a problem in other states too, but in Florida, the statute, the revocable trust statute says that in order to be able to amend, for an agent to be able to amend a revocable living trust on behalf of the person who originally signed the trust, not only must the power of attorney have the proper language and initials, but the trust itself must provide that this document, this trust, can be amended by an agent through a durable power of attorney. You need that matching language. You need two keys to unlock that door. And if you only have one, but not the other, we're hamstrung, right? So again, free forms don't contemplate these situations. Or the low cost, the $50 trust package that you get from, I'm not gonna name the company, but you know who I'm talking about. They're not thinking about these sorts of things. So now my client, who doesn't have capacity anymore, I'm dealing with their agent under a power of attorney, we can't do everything that we would normally want to do to protect them, or we're gonna be able to do it, but we're gonna have to go through a more expensive process, and it's gonna waste time in order to get it done. So this is a cautionary tale. When you're doing your estate planning, please, it's not me, that's okay. Go to a experienced estate planning attorney or elder law attorney. And of course, in Florida, we're here to help. We are an elder law firm, but we do traditional estate planning as well. And we're thinking through these long-term care issues that the free forms or the other attorneys who don't do estate planning or elder law are just not thinking about, because it's just not their area of law. So if you are interested in estate planning or Medicaid planning and you'd like to avoid probate, or you need help with probate anywhere in the state of Florida, please give us a call. We're here to help. If you found this video useful, please subscribe to the channel. Please give it a thumbs up. Help me get good information out to Floridians everywhere. Thank you for watching.